But we can't get any of that evidence. If the court will recall, more than a year ago, this court had a hearing where the court asked the juvenile prosecutors to appear and to answer to why they wouldn't give us this evidence. And they, in fact, appeared on Zoom. And this court had the opportunity to question them and find out.
And they said they would not be giving the evidence.
They refused.
Yes.
One of the few times I've seen a lawyer in this court actually tell the judge, no, judge, we refuse to do what you're telling us to do.
Whoa, did you hear that? A lawyer flat out told a judge, no, we refuse. That's not just bold. That's almost unheard of. This is the kind of courtroom drama that could make or break a case. Audience, what would you do if you were the defendant here? Fight for the evidence or take the risk without it?
All right, could I see the parties on Christian Alan Ruiz? All right. So the motion for speedy trial for dismissal, before we go on the record, so I can be clear about everything, it is for 2024 CR 008124.
Well, actually, Judge, all the cases are basically the same transaction, so it's going to apply to all of them. I'm sure I filed it in all the cases.
All right, could I see it for all cases, please? Let me check this. Motion to dismiss it? Yes. And is it there for all cases? Yeah.
I don't see it for. Okay.
All right, court is calling, and you've had a chance to review.
I have, Judge.
All right, court is calling 2024 CR 008124, 2024 CR 008173, and 2025 CR 007834, State versus Christian Alan Ruiz Garcia. Could I have parties announced for the record for the state?
Brandon Prada for the state.
Defense.
Raymond Martinez.
And are you Mr. Christian Alan Ruiz Garcia?
Yes, Your Honor.
All right, defense has filed a motion in each of these cause numbers to dismiss for lack of due diligence and violations of right to speedy trial. All right, defense, it's your motion.
Okay, now it's getting tangled. The key witness is a juvenile, and the records are legally sealed. Protecting privacy versus the right to a fair trial, that's a huge conflict. How do you think judges balance these competing rights? Drop your take below.
And Judge, I would ask the court to allow me to basically make this argument in all these cases. They're all one series of events that all happen together. So
Any
it
objection?
wouldn't be any
None from the
difference.
state.
All right, you may proceed, counsel.
But Judge, the court will recall, and I'll also bring up that one of the reasons for today's setting was to bring the defendant who was a juvenile who's now in TDC to court because we want him to testify in our case. We can't even accomplish that because nobody has his birth date. I don't have access to his birth date. State with, and I'm assuming Norma was never able to
All right, and
obtain that information.
the court will note for the record that defense counsel did file applications for a bench warrant. All right, you may proceed.
And so, Judge, this case happened in June of 2024. Specifically, well, I thought I had the specific date, but I don't. But the court has it before it. It's in June of 2024, Judge. The defendant in this case has demanded his right to a speedy trial when we filed our notice of appearance back on June the 11th of 2024. The cases got indicted on August the 8th of 24. So he's been under indictment well over a year and a half. In terms of the harm issue, Judge, I'm just going to go through what I've recited in my motion. A critical witness, Joshua Garcia, who was a juvenile at the time, a co-defendant, I think everybody can agree that he's in essence a co-defendant, was charged in juvenile court.
And just one moment, state, do you agree that's co-defendant?
It is, Judge.
All right, you may proceed.
And that his cases were adjudicated in the juvenile court. And then so much time has passed, Judge, he actually has been released from juveniles and since it was a certification, he was then sent to TDC, which We believe he's there. We haven't actually found him. And today we were set for purposes of seeing whether or not he responded or that he was presented to the court pursuant to our bench warrant. In this case, Judge, if you recall, the defense has been asking from the very beginning, because he's a co-defendant and because he has his own set of discovery, and more importantly, in this case, he had other aggravated robberies in addition to the ones that were with my client. So our theory was, well, it was our theory, our defense is that my client was participating in the particular case he was involved in under duress. And we wanted to be able to demonstrate in the trial of this case the character and the nature of this co-defendant, what he had done in the past, his use of weapons, his MO, if you will, to show that because my client was only involved in this particular date and he wasn't involved in the others, to help support our suggestion that he was operating under under duress. But we can't get any of that evidence. If the court will recall, more than a year ago, this court had a hearing where the court asked the juvenile prosecutors to appear and to answer to why they wouldn't give us this evidence. And they, in fact, appeared on Zoom. And this court had the opportunity to question them and find out.
And they said they would not be giving the evidence.
They refused.
Yes.
One of the few times I've seen a lawyer in this court actually tell the judge, no, judge, we refuse to do what you're telling us to do.
Here's the kicker. The defense tried everything. Petitioned juvenile court, requested bench warrants, but got blocked at every turn. Over a year without access to critical evidence? That's a nightmare scenario. This is why the right to discovery is so crucial. Without it, the defense can't even present a duress claim.
Okay, so we stepped back from that and we regrouped. We found a provision in the code that says that we can petition the juvenile judge to have a hearing and to determine whether or not circumstances exist where he would order the disclosure of the records. So we did that. He denied it. They argued against it. He denied it, except to the extent that he said we could review the file that pertained to our case. Well, that was kind of pointless. We already have the file that pertains to our case because we have discovery from my client. But we'll give it a go. Never got them. We provided case numbers to the state. The state said we don't have those files. And to further clarify the record, the juvenile prosecutors told us that they, in essence, took into consideration the cases that my client is charged with and never really pursued them because he had so many others that he got prosecuted on. So they weren't even sure where those cases were in the system. Not sure they even got filed on.
And when you say other cases, you're speaking about your client's co-defendant.
Correct.
All right.
The co-defendant had double-digit number of aggravated robberies. And so the ones they chose to prosecute didn't coincide with my client's case, unfortunately. So that was another area in which we were not able to get the records. So we said, well, let's get the defendant here. Let's get the co-defendant here. Maybe we can get through him what we need, but we can't get him here. And I will tell you, Judge, that Abe Garza, and I think we've talked about this before, and I think he's been here before, is the juvenile's attorney. And he has suggested to me, and as an officer of court, I will tell you that his advice to this client is going to be not to say anything, which is understandable because those cases weren't prosecuted. They still could be, theoretically. And he could expose himself to all kinds of problems, not only with those cases, but with perjury and everything else. So even if we were able to get him here, I don't believe we would have been very fruitful.
All right.
But
and the court will note for the record that in regards to discovery, the request by the defense for discovery has been well over a year. The juvenile prosecutors did zoom in and no one had any objections to the prosecutors zooming in. And they informed the court that they would not comply with discovery. And so state, here's my question. With regards to juvenile, if it is information that is exculpatory, basically what I'm being told is you don't get it because it's a juvenile. They won't even give him the date of birth of the witness in order to have the witnesses appear by bench warrant. So, and that ship has sailed with regards to bench warranting him here because this has been over a year. So that's what my understanding is from juvenile prosecutors, and their understanding of the law is that even if it is exculpatory, his client is not entitled to it because the other person is a juvenile.
And Judge, that's as confusing to me as it is to everyone else here. Under 3914, if it's relevant, then it is to be given to the defense. I don't know. My knowledge of juvenile law is rudimentary at best. My argument would be that any discovery that would come from the co-defendant would also be, all this stems from the same incident. So all of the discovery, be it for the co-defendant or for the defendant standing here, would be exactly the same because it all stems from the same incident.
But I mean, do we really know that? Because he hasn't been given access to it, and defense is entitled to exculpatory evidence. And I will say that the prosecutors in this court, you all are not the prosecutors who denied this defense the discovery that they needed. However, you all are all working for the district attorney's office, so everybody's responsible for discovery.
Judge, sorry if I could just
Yes.
chime in here, but I think like the
And
distinction.
if you could announce.
Yes, it's Megan Galloway for the record. The distinction in this case is that there's a legal like reason why it's not being provided.
Mhm.
I believe under the family code, it's protected because the co-defendant was a juvenile at the time. And so we've certainly exhausted our resources. I understand that the state is a state and we are working together. However, the divisions are walled off from each other, so we don't have access to that information. So I want the record to be clear about that. I am not in possession of those materials. And then albeit whatever the juvenile prosecutor did come in here and say, the petition to the juvenile court was still made. And that court determined that it should not be turned over. And so at this point,
And I know that the prosecutors in this court did all they could to get the information to defense. Is that correct?
Hold on, plot twist. The prosecutor just said the date of birth was in discovery all along. If that's true, it shakes the defense's whole argument. Judges now have to weigh credibility and procedural fairness. You can literally feel the tension in this courtroom.
The attorneys in this.
In this court, of course, Judge,
Yes.
and I don't dispute anything that counsel just suggested to the court, but that could have been avoided.
Mhm.
When they went to prosecute that juvenile, all they had to do was call the prosecutor in the 187, say, hey, we're getting ready to go forward to this guy. This is our deal. We're going to work out. Let's discuss what you're doing with your case. Maybe they would have made mine go forward first. I mean, there's so many ways it could have been avoided.
Well, I know there are different ways it could have been avoided, but I'm just going to deal with the facts that's
Yes.
being presented before me. And I want the record to be clear that the prosecutors in this courtroom did all they could to obtain the information that you were requesting.
I'm not disputing that, Judge.
And what I will say again, it appears that prosecutors in other courts, whether it's juvenile or not, people think that the law means that if there's exculpatory information, if it's a juvenile, too bad, so sad for your client. And the defense can't even get to the point of his defense of perhaps duress because he's not being given access to the information. And this has been going on for over a year. But I just want the record to be clear that the prosecutors in this court, I don't think, I know that you all did all you could to obtain the information.
then Judge, just to address one thing, the date of birth of the co-defendant was provided in the discovery that we received. So
Okay. He should have that.
has
Okay.
that.
All right.
Um,
And I understand what you all are saying about the bench warrant with that. But we're still at a point where this court thinks under the law, the defense is entitled to exculpatory information, whether the person is a juvenile or in the juvenile system or not, because then what are we really doing? He can't present his defense, and nobody knows, for the record, nobody knows if it's exculpatory or inculpatory because he's not being given it. And obviously based upon what the defense is presenting to the court, that their defense is or will be, he's saying as an officer of the court that he believes the documentation would show that, potentially.
It would help us to prove that point, we think, Judge.
So is there anything else from either side?
Judge, I just understand that. I understand what the court has explained. I just don't believe that dismissal is a proper remedy in this case. And so I don't know if the court would be able to reach out to Judge Shaw, because I mean, that was his ruling. So at this point, my hands are tied because that was his ruling under the family code.
Mhm.
And I would agree that neither party knows what is in those records that are over there. However, if we're getting to the point of, or their argument of duress, there are pieces of evidence where, in this case, that were turned over, out like statements from the defendant that do address that if they would like to put it forward.
All righty. Is there anything else from either side?
I think our position is pretty clear, Judge.
All right, just give me 5 minutes and I'll give you my ruling. Thank you.
Your Honor.
And just like that, the hammer drops. Dismissed. All felony charges gone because the system failed to provide the evidence needed for a fair trial. Sometimes, when the rules tie your hands, judges have no choice but to protect justice the only way they can. What do you think? Was this the right call or too extreme?
All right, we're back on the record in 2024 CR 008124 and 2004 CR 008173 and 2025 CR 007834, State versus Christian Alan Ruiz Garcia. Just for the record, the court will note that discovery issues have been ongoing in this case since, at least according to the court's docket, since October 31st, 2024. And with regard to the defense's motion to dismiss, and each of the cause numbers, the court will grant the defense's motion to dismiss for want of speedy trial. And it'll be based upon the defense's inability to proceed with trial due to the lack of discovery. Is there anything else?
No, Your Honor.
All right. Thank you.
Thank you, Judge.
Thank you,
Excused.
This is one of those rare cases where the law and human drama collide. Over a year fighting to get a fair shot, blocked by red tape. And in the end, justice wins, but only because the system recognized the unfairness. Imagine being in that defendant's shoes. Would you feel vindicated or frustrated? Sound off in the comments.